Let's talk a little bit about what we're going to court in. It is a homicide prosecution. The defense attorney that we will see in court is the defense attorney for Myles King. There's also a co-defendant in this case. The allegations here are all surrounding a pending motion to dismiss centered around failing to disclose discovery. And the Commonwealth also agreed to the continuance. Why? Because there's a new DA on this case, not Adam Lally, who had the case originally. And the new DA on the case seems to acknowledge that all of this is just ridiculous. But for years, Adam Lally did not turn over discovery. And when we watched the last hearing, which we will link down below, when we watched the last hearing, he was like, I mean, they'll get it eventually. Discovery is an ongoing obligation. First of all, that's not what that means. Discovery being an ongoing obligation means that if something new comes in, you are still obligated to turn it over. Like, just because the discovery deadline is passed, if you receive something new, you still give it to the other side. It's not like discovery ends. New things mean new disclosures. It doesn't mean turn it over whenever you want to. That's not what it means. And it seems that everybody's been rolling with, we'll turn it over appropriately. No, you won't. Part of the fault I find in this is not just the district attorney's office for not doing their job. It is ultimately the district attorney's responsibility. And if law enforcement is not giving things to the district attorney, it is the district attorney's job to escalate it. If it needs to be escalated to the court, you go to the court. And then you say, I need a court order. No one's giving me what we're supposed to do. There are processes and steps you can take as an attorney to try to get things turned over. You don't just wait 3 years and go, meh, it'll be fine. So the district attorney is responsible for forcing law enforcement to do their job. Should law enforcement just do this? Yes. But if they don't, it then goes to the DA. And if the DA is not doing it, it then goes to the judge. And I don't know how anybody's gone this long without turning over discovery without sanctions. And the problem is, we might now be at the point in time where the sanctions that are appropriate to remedy the situation means that a murder case gets dismissed, which I can't imagine how devastating that would be to a victim's family. It's like, hey, this thing happened to your loved one or your son, your brother, your friend. And the person that we have charged with doing that thing isn't going to go to trial because no one did their job. It's incredibly frustrating. And so my level of annoyance is high with this because it's A, not that hard. B, they went to a grand jury, they had this shit. It's not like they don't have it. They have it. Turn it over. And C, the attitude threw me sideways. I don't know if this is just his default setting, but when you have a job where you are responsible for whether or not people go to prison, you have to handle yourself so that you can handle your work. You have to. And your work has ethical obligations, and you have to handle those.
We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th, on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Oh, well, there it is. 1, 2, 3, 4, 5 cases that are Proctor cases waiting for the feds to disclose the Proctor discovery. At this point, I think you protective order it and turn it all over. And then you fight about whether it's admissible. Like, the shit's so far out of the horse on that, but Proctor's probably waiting for that discovery too.
The Commonwealth has provided you, as best we can, what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date. But at this point, I know ADA Hickman has worked very hard to go through the material.
Attorney Scapicchio.
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have two dueling charts, huh? So you have the Commonwealth's chart and your chart.
Yes,
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure
Well,
out
Judge,
a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday.
Do I have a list of the items which are new or which you claim to be new, and that I can then cross-reference against the Commonwealth's list, which you say are prejudicial or are exculpatory and you're behind the eight ball because of the late disclosure, notwithstanding the continuance?
Yes, Your Honor. I
Okay,
am.
where will I find that?
So where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. Because I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say this is where we are and this is where we stand. But if we don't have everything, and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say this is,
Well,
now this
as an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
Yes, sir.
That's what I think we were shooting for. We understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
What happened in court today in the Myles King case? This case is undergoing a discovery battle that involves Trooper Proctor and attorney Adam Lally. The defense has made a motion essentially to dismiss the case as a remedy for the failure to turn over discovery and Brady violations, that the discovery that was not turned over is prejudicial to the defense. The court has already taken remedies in this case in that the defendant, who had been in custody for 3 years, is now out of custody on a very low bond pending trial that has been delayed. So the defense has time to go over the late discovered and newly turned over evidence. So in continuing the trial, part of the continuance was allowing the defendant out of custody. And the court addressed and noted that remedy a few times in hearing today. The court then put a hearing over for August 12th, and that's going to be a hearing to set another hearing. Today, we were supposed to be continuing the evidentiary portion of the motion to dismiss. That's not what happened. The court said at the end of the last hearing, I asked the parties to get these 2 things for me. And those 2 things are not all the way done. So I need everyone to go get this done and come back. And the court was asking the defense of that more because it is the defense's motion and the defense's burden. So the court was asking the defense, have you compiled with the prosecution a list or a chart of every piece of evidence and when it was turned over? And the defense had a few charts and the prosecution had a chart, and the court goes, no, I want you guys to get together and figure out what each item is and when it was turned over. Of course, the problem with this is that the prosecution didn't bate stamp everything, so there's no continuous numbering system so that you can refer to everything the same. And the court's like, I need to know when things were turned over, and then I need the defense to identify what things are being argued as being materially prejudicial in the motion to dismiss, since the first remedy has already happened, the case has gotten delayed for more time and the defendant has been let out of custody. So what we are going to see on the 12th, I suspect, is that the court is going to have all the attorneys in and they are going to figure out exactly what documents the evidentiary hearing is going to focus on and what documents got turned over and when, and this side quest of what's going on with the feds and Proctor's text messages, because there are 5 cases the court listed today that are waiting for the feds to turn over discovery about Proctor's phone. And apparently the feds are having a meeting today to turn over or discuss turning over that discovery. And so the defense is like, we don't know yet if we need to make a motion to intervene to get this information because we still don't have it yet. So for the defense, it's kind of like playing whack-a-mole because the defense can only address the discovery that they have. And it seems that that is now just a dripping faucet and discovery keeps just showing up. Where have we seen that before? It's just drip, drip, drip. And the defense is like, every time I think we have everything, we don't. And the court's like, okay, but we need to address what we have and what the motion is regarding and what things are prejudicial. The bar in Massachusetts on a motion to dismiss is a high bar for the defense to prove that the remedy needs to go beyond just giving more time for trial. Oftentimes, failure to turn over discovery, the remedy is either we have a trial, or if it's on appeal, hey, there's going to be a new trial. But what is clear is that in Massachusetts, the Karen Reed case shined a big old spotlight on the fact that this is not just an issue in the Karen Reed case, but that this is a larger issue with discovery. And cases are lingering for years without things being turned over. And the defense today in court said there are still search warrants they don't have. At the last hearing, the defense noted that they had gotten like 1.5 of 6 search warrants that were used at the grand jury at the very beginning of the case. So this is an ongoing issue. And the court's like, I'm trying to really wrap my head around where all this discovery is, when it is coming in, when it was turned over, and WTF is even happening. But when the court listed 5 cases that are waiting on Proctor text messages, the Walsh case was one of them. We haven't talked about that case yet. A lot of you have asked me to. We will probably get to it after Donna Adelson because it's pending trial as well. But for discovery to sit from 2021 to 2025 and not get discovery turned over that was part of the original grand jury is wild. There's no reason that this should be taking as long as it has. Somebody has it in a file somewhere, turn it over. So today we did not see Adam Lally or Trooper Proctor testify. And on the 12th, we're not going to see them testify either. On the 12th, the judge is going to continue to try to get their hand around exactly what items of evidence are at issue for the motion to dismiss. And I have empathy for the defense trying to say, well, nothing is bait stamped. So we're trying to piece together what we got and when over years. And then we're trying to figure out what we don't have that we know we don't have, aside from the things we might not have that we don't know that we don't have. And the defense at one point said, if the prosecution's going to certify we have everything, then at least we know the dripping faucet is going to stop. The prosecution didn't say anything to that, and it hasn't been certified that discovery is complete. I understand the frustration. I understand the court's frustration. But it seems to me, if this is an ongoing issue, which it seems to be, that the remedy is if the prosecution is not done with discovery within the period for discovery, then anything that comes in after that date doesn't get used in trial. And if you can't use it at trial, then unless you show me good cause, it's not coming in. And if it's helpful for the defense and they don't have enough time, they're not getting a continuance. Your case is getting yeeted. But it seems that the bar for the courts to make that decision is incredibly high in Massachusetts based on their statute and case law. So really holding discovery that's not turned over against the prosecution seems to be one of the only ways to turn this around. But the case law doesn't have a ton of teeth to it. even if the discovery is helpful to the defense, because the remedy is, well, you can have more time to go to trial. So today, nobody took the stand, and the judge said, I need more information. And the defense attorney and prosecution had 3 hours after court today to try to sit down with their files and see what has been turned over and when, and try to take those lists and like merge them so that the court knows every piece of evidence in the case, which can be thousands of pages in a homicide case, every piece of evidence and what the issues are. When will we see Attorney Lally and Proctor on the stand in this case? I don't know. It's not going to be the 12th. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.